Hello, my name is Sue Millar. Together with my colleague Ed Davis, I head up the finance litigation team at Stevenson Harwood. We have discussed the potential emergence and indeed submergence of an implied duty of good faith in previous webcasts. The English common law has been traditionally reluctant to recognise a principle of good faith of general application. The decision of Mr. Justice Leggett in the 2013 case of Yam Zhang and International Trade Corporation Limited threatened to overturn that traditional reluctance. In that case, the judge had no difficulty in implying a duty of good faith into any commercial contract based on the presumed intention of the parties. His starting point was that contracts were made against a background of unstated shared understandings and norms of behaviour which informed their meaning. A paradigm example of such a shared understanding was an expectation of honesty. As a matter of construction, therefore, it was hard to envisage any contract which would not reasonably be understood as requiring honesty in its performance. Perhaps buoyed by this decision, we at SH have seen a number of cases in which assertions of a breach of an alleged duty of good faith have been made against client banks. Such arguments have not, however, generally been successful. Indeed, 2 years down the line, the Yam Zhang decision is looking very much like a high watermark. Although the courts have continued to be vexed by arguments surrounding good faith and the related issue of contractual obligations to act reasonably, the run of authorities, at least in a banking context, have limited their effect to a requirement to act rationally or with Wednesbury reasonableness. As many of you will recall, it had previously been held in a 2008 decision predating Yam Zhang, Sosima and Standard Bank, that when one party to a contract has the power to make decisions that affect both parties, the party exercising such power was required to do so honestly and in good faith, and not arbitrarily or capriciously. For a time, it looked like the first instance Barclays Bank and UniCredit decision had introduced a requirement that the exercise of such power should be objectively reasonable, in the sense that a reasonable commercial man might have reached the same decision as that actually made. The Court of Appeal appears to have shied away from this in its 2014 decision. The clause in question required Barclays to determine whether to give its consent to the termination of certain guarantees in a commercially reasonable manner. The court recognised that it was not easy to express a test for commercial reasonableness, but suggested that the party who had to make the relevant determination would not be acting in a commercially reasonable manner if he demanded a price which was above what he could reasonably anticipate would have been a reasonable return from the contract which he had entered into and which the counterparty sought to terminate at an early date. Lord Justice Longmore went on to suggest that this was equivalent to conferring a discretion to which the principles of AP Picture Houses and Wednesbury Corporation in 1947 applied. A decision is Wednesbury unreasonable, or indeed irrational, if it is so unreasonable that no reasonable person acting reasonably could have made it. The reasoning of the Court of Appeal in Barclays and UniCredit has been followed in Fondazione Inasarco and Lehman Brothers Finance SA, in connection with the obligation of the non-defaulting party to reasonably determine in good faith its loss. The dispute arose in connection with Inasarco, an Italian pension fund's investment in principal protected notes issued by Anthracite Rated Investments Cayman Limited, or ARIC. Lehman Brothers agreed to protect the principal of the notes under a put option documented under the 1992 ISDA Master Agreement. The put option was automatically terminated following the collapse of the Lehman Brothers Group on the 15th September 2008. By reason of elections made in the schedule to the Master Agreement, it followed from the automatic termination that an amount will be paid equal to the non-defaulting party's loss in respect of this agreement. If that amount is a positive figure, the defaulting party will pay it to the non-defaulting party. If it is a negative number, the non-defaulting party will pay the absolute value of that amount to the defaulting party. The master agreement provided that the non-defaulting party's loss was the amount that party reasonably determines in good faith to be its total losses and costs. In considering this issue, Mr. Justice David Richards stated his view that the relevant authorities now quite clearly establish that in considering whether the non-defaulting party has reasonably determined its loss, that party is not required to comply with some objective standard of care, as in a claim for negligence, but, expressing it negatively, must not arrive at a determination which no reasonable non-defaulting party could come to. It is essentially a test of rationality, of the type developed in the quite different context of public law duties in Associated Picture Houses and Wednesbury Corporation. A recent commercial court decision deals with a related issue. Clauses conferring on one party the discretion to consent to a request by another party are common in finance transactions. Such clauses usually provide that the requested consent should not be unreasonably withheld. What, however, is the consequence if the consent is never requested in the first place? In BG Global Energy and Talisman Sinopec Energy 2015, the judge held that if consent was not sought at all, the question of whether approval could or could not have been unreasonably withheld was irrelevant to the issue of breach. The defendant could not therefore argue that if it had sought consent, the claimant could not have reasonably withheld it. Previous cases, in the context of landlord and tenant law, had decided that if consent was not sought, then any purported action taken in its absence was of no legal effect. That remained good law in relation to assignments, but the same did not automatically follow for all contractual provisions requiring consent. Each provision had to be read on its own terms. In the BG case, the judge decided that the defendant had breached its contract with the claimant by failing to seek consent, but the action which it had taken in its absence was legally effective, and the issue of whether or not it would have been reasonable for the claimant to withhold its consent was relevant to the assessment of damages flowing from the breach. In other words, it was open to the defendant to show that if it acted in accordance with its obligations and sought consent, the claimant could not have reasonably refused it. If successful, any damages award could therefore be nominal. So, looking into the proverbial crystal ball, what are the practical implications of these decisions? Going forward, it appears that in all but the most exceptional circumstances, the emerging general duty of good faith has submerged. Its application is limited to a duty of rationality or Wednesbury reasonableness. Put another way, the duty is a negative one. Not to act so unreasonably that no reasonable person acting reasonably could have acted in the same way. There are a lot of reasonables in that sentence. The BG case has the potential to have significant implications on finance transactions. As I noted earlier, clauses which confer on one party the discretion to consent to a request by another party are common. Leaving assignments to one side, it no longer automatically follows that an action taken in breach of an obligation to seek consent has no legal effect. This will have implications on the strength of the parties' respective bargaining positions, both when initially negotiating the transaction and also during its performance, to say nothing of the assessment of losses flowing on any breach.